The National Prosecuting Authority has welcomed the Supreme Court of Appeal's decision dismissing former President Jacob Zuma's reconsideration application. Zuma's legal team had approached the SCA to have the lead prosecutor on this case, Billy Downer, removed from the corruption trial. But Zuma claiming that Downer leaked his medical records to the media and saying that Downer was a conflicted prosecutor who's also biased. Well, the NPA says the trial will resume on the 15th of August in the Pietermaritzburg High Court. Joining me now is the spokesperson of the National Prosecuting Authority, Advocate Mthunzi Mhaga. He speaks to us alongside legal analyst Mpumelelo Zikalala. Gentlemen, thank you very much to both of you for your time. Advocate Mhaga, allow me to just quickly talk to you about the breaking news this morning, and that is the alleged arrest of, among others, the former Transnet CEO, Siyabonga Gama. Are you able to confirm that for us? I know that the Investigative Directorate is your unit that is handling this matter specifically, but can we get your quick thoughts on this, whether or not our information is correct?
There is an arrest of former Transnet executive that took place this morning in a collaborative work between the Hawks and the Investigating Directorate. However, I am not able to go into the details of the arrest because they are expected to appear in Palm Ridge Magistrate Court today, this morning. So all the details will be revealed in court when they make that appearance. All
right, I'm not going to persist on the names, but the Investigative Directorate at court intimating that these are indeed cases linked to state capture. If that is the case, Advocate Mhaga, would you say that this is now part of that major movement that had been promised by the NPA, that there is going to soon be arrests around cases involving state capture?
That is correct. You recall that the National Director had indicated that there will be seminal cases that will be enrolled in court in the next 6 months. So this is one of those cases.
Wonderful. Let's get back to the matter at hand, and that is that involving the former President Jacob Zuma. So you have seen the decision of the Supreme Court of Appeal. What's the NPA's next step? In fact, what are your wishes at this stage around this long-standing matter?
Our wish and our hope is that this long matter, which has been quite a protracted process, dating back over 17 years ago, will finally resume on the 15th of August. We will channel all our resources in ensuring that we oppose any further postponement, because we believe clearly that it is not in the interest of any of the parties for the matter to be further delayed. So we're hoping that by the 15th of August, we will not have any further delays in the matter. Our witnesses will be ready to testify against the two accused so that we can sustain the charges against them.
Mr. Zikalala, let's come to you. Advocate Mhaga says they're hoping for no further postponements. But who's to say that the former president might not approach the Constitutional Court?
I think only if we look at the history and you look at it, we are here because there was a petition that was made to the SCA. And in this case, they basically say, no, we want to go to the Constitutional Court. In our request for a reconsideration, we have raised certain matters in which we have highlighted access to court. Let's remember that Section 34 of our Constitution guarantees every single human being or every single person in South Africa the right to access to courts. So according to the former President Legal's team, if you look at their papers, they basically say, we want to go to court and be able to state our case. We so believe that the Constitutional Court is the right platform to discuss this matter. We want to extend the interpretation of the charge to prosecute. Linked to that is that this is a matter that's also been dealt with, or the highest decision of this particular case has only been at the SCA. It does need some constitutional consideration so that at the end of the day it's easy to make a determination and help all the other cases that may come along in terms of saying when a prosecutor has behaved in a manner or is alleged to behave in a manner which Advocate Billy Downer has done, what are your resources or are the current avenues which are available and that have been highlighted by Judge Kuhn in his previous judgment, and enough or adequate to make sure that they're able to protect the rights of the former president or any other accused in that matter.
Yeah. Advocate Mhaga, the other element here, and I'm just now reflecting on the statement that came out last night announcing this decision of the SCA to dismiss the application of the former president. There was a very specific issue around delays and the legal team of the former president. I suspect that there's going to be some major haggling around the delays, not just around the matter that is before the Pietermaritzburg High Court, but the other one that has to do with the arrest of the former president for contempt of court. You'll remember that there is that application that is now seeking to have his release on parole reviewed. Now, those matters, do you think that that could be something that could be brought forward by the former president to say this is part and parcel of why we're saying the judicial or the legal system in South Africa is somehow biased against the former president? The office of the Chief Justice going to some lengths trying to say that it is not the fault of the Supreme Court of Appeal President, Justice Mthunzi Mhaga's fault that there were delays around this. It was administrative errors within the office.
Yeah, they do indicate in the statement that those are issues that they are addressing. But insofar as the medical parole issue is concerned, it has no bearing on the corruption case that is in the Pietermaritzburg High Court. Those are two distinct cases. They shouldn't be linked together at all.
Mr. Zikalala, do you foresee anything of that sort that could be brought through the back door somehow around these specific delays in dealing with these two matters that were before the SCA?
I think there may be an allegation of saying all that we want is we want our day in court, not only on paper, but we want to be present and be able to make submissions. Now, these particular administrative errors that have occurred are certainly prejudicial to the former president, and it is part and parcel of why they should be given an opportunity to make verbal submissions. Now, the Constitutional Court is not obliged or obligated to listen to all of those submissions. The Court is simply there to say, let us look at what the procedures and the law says. Let us look at our powers in terms of what we can deal with. Is this a matter that falls within our exclusive jurisdiction? Are they matters of Chapter 2 of the Constitution which must be considered? Have they been considered in circuit before? Or is it the first time in which they're going to be considered? If it is the first time, are there any things in which we can help to develop the legal jurisprudence of our country? If there's none, then they would say, no, we're not going to consider this matter. Please go back to the Pietermaritzburg High Court to deal with your matter. But taking from the manner in which things have been going, I would highly suspect that even if a decision such as that one would occur where this petition is dismissed, they will then make another application in terms of reconsideration of the order, and then say you fail to apply the rules or you fail to apply your mind in this matter, can you please look at it again, which then would have a delay in the date of the 15th of August. However, if they are going to accept the decision of the Court when the Court says we are going to dismiss your matter, we may see the 15th of August be the date in which the first witness would go into the witness box. But it highly depends on what the Court is going to say.
Mr. Mhaga, if indeed this matter does end up at the Constitutional Court, would I be speaking out of turn to say you will be forced to accept yet another postponement?
A possibility exists that it may have that ripple effect, but we are not focusing on that at the moment. We are focusing on ensuring that the matter resumes on 15 August because they have not intimated that they are going to the Constitutional Court. So that's rather speculative.
Yeah. All right. Let's then talk about the possible witnesses that may come through. I think at some point we even saw the current Minister of Public Works, Patricia de Lille, who was at the Pietermaritzburg High Court at the time that we all assumed this trial was indeed going ahead. Who are some of the people that are going to be your key witnesses on this?
Well, the issue of witnesses and evidence is a prosecutorial strategy that we don't ventilate through the media. But you are correct, Minister Patricia de Lille is one of the witnesses.
Yeah. All right. Advocate Mhaga, not giving much away, Mr. Zikalala, and it forces me to come back to you about what you think are going to be the key strategies of the NPA in trying to see to it that this long-standing trial does finally get underway, but more importantly, there's credible evidence that is put forward.
I think the NPA is well aware of the standard of proof, the burden of proof which applies to them, which is to say that the former president is guilty beyond reasonable doubt. All the statements and the witnesses must be able to state exactly that. The main point being that there's some type of gratification that you have been able to achieve, and it is through your influence in which you have been able to achieve this gratification, and you've assisted individuals so that they are a step ahead beyond any other person would have made this particular application in this government institution. So it would be easier to prove those particular gratifications if the witnesses that are there will be able to deliver the evidence well. Now, I always come to this. The quality and the quantity of the evidence is absolutely crucial so that it is able to bring you that conviction in which you are looking for. One of the worries which have taken place in this matter is the amount of time in which it has occurred. I think it's plus minus 8 years. Now, the question would be, will those witnesses be able to remember the intimate details of what exactly took place? Is the evidentiary material which is required in this particular matter that have previously caused delays with this matter starting be available and be able to be interpreted in a much more easier way? The next question leading to that would be, what are the types of common matters in which both parties have agreed to, so that to eliminate those particular matters from being disputed? So the list of admissions is going to be absolutely crucial. But at the end of the day, the starting and the ending of the trial within the shortest amount of time is beneficial to both parties. You need witnesses to prove your case. The former president needs witnesses to prove that he's innocent.
Mr. Mhaga, let's complete the conversation with you. We're not going to talk witnesses. You've already heard the concerns from Mr. Zikalala, but perhaps one critical element that I think all South Africans would be aware of around this matter of the arms deal, and in particular involving the former president, was the so-called encrypted facts. That particular piece of evidence, how crucial is it going to be for your case?
Every piece of evidence, every evidential material that is in our possession will be used to sustain the charges, and therefore it's important.
And so you still have it in your possession?
I'm not going to comment on that, unfortunately.
Advocate Mthunzi Mhaga speaking to me alongside Mpumelelo Zikalala. Gentlemen, thank you very much for your time. I've got to tell you, Advocate Mhaga is a difficult customer to deal with.